Particularly want to welcome today the students from the William and Mary College of Law who are observing arguments today. And we're ready for our first case, Gardner versus Bondi. Mr. Johnson.
Good morning, Your Honors. Your Honors, I must point out something that I discovered in preparation for today's hearing, and is that one of our footnotes didn't make it into the final version in the PDF version. And that footnote referenced a 2024 conviction that my client had for misdemeanor shoplifting, concealment of merchandise. At the conclusion of today's hearing, Your Honors, we will move before the court to amend that, to include that second footnote.
Okay, and the second footnote with the additional conviction, is this the first opposing counsel's hearing of it?
I did advise counsel this morning before we got it.
Okay, good, thank you.
Night.
And so how does that impact your argument?
Well,
if
we
at
would
all?
argue that it's a lesser offense of misdemeanor larceny, and that it does not constitute a CIMT. We would, in our footnote, we make some arguments as to why the court should not consider it a CIMT.
And a CIMT, for people listening, is
okay.
a
Crime
conviction.
of moral turpitude,
Yeah.
Judge. I'm sorry. Your Honor, the other issue that we are here to address is the PJC, which has overwhelming impact for North Carolinians, and especially North Carolinians that have immigration issues. Judge, in this case, my client was required to complete community service before receiving a prayer for judgment continued. A common practice among practitioners that we call earning a PJC to warrant that discretion, to warrant or to merit that discretion. In this case, my client was asked to complete community service before the court entered a decision. And this is common, as I indicated.
And you're saying that, are you arguing that the timing of it is what makes it not a punishment or a
Yes,
sanction?
Judge.
Simply the timing?
The timing is an extremely important element because the timing occurs, Your Honor, typically before a respondent or a defendant enters a guilty plea.
But what authority then would the court have had to impose community service as anything other than a sanction or a punishment?
This is the authority. The judges are empowered with the authority to issue a PJC or prayer for judgment continued. And so what the judges are doing, Your Honor, is they're saying that they will not issue or use that discretion to issue a PJC if this condition is not complied with. And so this is distinguishable from
Don't we have a case about timing? Doesn't Jaquez versus Sessions say that the INA requires a finding of guilt and some sort of punishment, but does not require that the two elements be entered or imposed simultaneously?
That is true, Your Honor.
The timing is not the issue, it's that both things have to exist.
Both things have to exist, and the timing is not the sole issue. The other issue is, do you consider the community service to be a punishment? Again, this was a condition in order to earn a benefit. And what we're saying is, if you look at, Your Honor's look
So
at...
community service in this instance wasn't a punishment, it was a benefit?
It was a requirement to obtain the benefit, Judge, yes.
And was the benefit a lesser punishment?
The benefit was the PJC.
Right.
Which is a lesser punishment?
Well, a PJC is not a conviction. And so the idea is that the respondent or defendant will receive not a conviction. A judgment will not be entered if they completed the community service. Now, if I may say, this is distinguishable from other instances where PJCs have been issued, where the court says that subsequent conduct should be monitored, such as ordering a respondent to not flee from prison, to continue obeying the law, or to not violate motor vehicle laws, as in Florence v. Hyatt, or to order no contact to the victim and immediate family, as in Walters v. Cooper. Judge, in all of these cases, the court found that those actions by the court, or those requirements by the court, were not considered punishments. In this case, what happens is client went to court, initiated that he intended to enter a guilty plea and wanted to request a PJC. Court entered a requirement that the client comply and complete community service hours. Client returns to court showing compliance, and then the court enters a PJC. And what we're saying, Judge, is that this is a condition that's placed on a defendant prior to the court entering a PJC. There is no ongoing monitoring. there is no ongoing requirements that the defendant has.
But how do you distinguish in North Carolina, there's, the cases, and one of them is, I think it's State v. Pop, where it says community service is punishment?
If it's, if you look at the timing of this particular case, Judge, again, this happens before, and it wasn't just punishment, State v. Pop, Your Honor, if I may. It was abide by curfew, complete high school, can meet 100 hours community service, remain employed, and write a letter of apology. So the court had imposed a number of conditions that are distinguishable from this case. In this case, Your Honor, my client was required to complete community service before the entry of a PJC.
Isn't the question in front of us, though, whether this qualifies as punishment or restraint on liberty under federal law? North Carolina doesn't control our interpretation of what is punishment or restraint on liberty or the statutory language, you know what I mean?
That is correct,
What that
Your Honor.
means for federal law, right? Now, Gonzalez tells us we look at state law for the substance of what is this penalty, what was imposed.
Sure.
But North Carolina law can't tell us what this term means for purposes of federal law, can it?
It cannot, Judge. It's persuasive. It's to give the court guidance on how courts have treated the issue.
And we defined that in Gonzalez, so how does this satisfy the definition there?
Well, in Gonzalez, the court ordered that a fine, or determined that a fine would be punishment, because it's punitive in nature. In this case, Judge, and based on my experience, when someone complies with a condition precedent, it's not treated as a punishment. It's treated as someone who is seeking a benefit, and that benefit being a PJC. So we would say, Judge, this is not a fine. It's not equivalent to a fine. It's not punitive in nature.
Well, we defined it in Gonzalez as a punitive sanction, i.e. one that's intended to discipline or deter and is proportionate to the underlying offense conduct, that's what is a punitive sanction or a punishment of some sort. So this community service seems to satisfy all of those requirements, doesn't it?
I would argue that it does not, Judge, respectfully. There's nothing in the record to suggest that the court, when requiring the community service to earn the PJC, indicated this would deter or be used as a punishment against the defendant. It's merely a prerequisite for the respondent or defendant to show that he has complied with the court's conditions. He's met the court's conditions so that the court could enter the PJC. So I would argue, Judge, respectfully, that it's not punitive. It's not a penalty. It's not to deter future.
If community service was entered after the judgment, would it be punitive?
Yes, because it would be part of a court's judgment, Judge.
So for you, timing really is everything.
I think timing.
Before judgment, community service is somehow not punishment, but after it morphs into being punishment.
It goes into the mindset of the court. And the court is whether or not it would be considered a punishment or not, Judge. I think that once a court enters judgment, it then requires a set of conditions, including, but not limited to, community service, that is intended to punish, deter, and change behavior. Whereas when the conditions are requested prior to the entry of a PJC, that's considered more warranting favor or meriting a PJC, and we would consider that, Judge, not to be punishment or punitive in nature.
But he can't get the PJC without doing the community service.
That is correct. In this case, Judge, the court did have him do community service in order to receive the PJC.
So under your theory, what if a judge sentences someone to time served, say that they're, arrested, they're incarcerated while they're awaiting their plea, their sentencing, and then the plea and sentencing all happen at the same time.
Yeah.
They plead guilty, and the judge says, I sentence you to time served. Under your theory, that would not be a punishment because it happened before the guilty plea, before the judgment.
Well, no, I would consider that the difference, I would say, Your Honor, to answer Your Honor's question, is that judgment was not entered here because the PJC is not analogous to a
Before
time
the-
served sentence.
Before the plea, let's say.
Okay, so in this case, Judge, the question becomes, and why I think is different again, is that one is a judgment and one is actually just a PJC. But I would say timing is everything in these cases, Judge. I don't think we can get away from that. And I think this is distinguishable from the fact pattern that you just provided, in that it's what someone must do in order to warrant that favor. In your scenario, Your Honor, the time served scenario, it's someone who's already serving the punishment prior to the entry of a plea, and subsequent to that, the court's decision as to what the punishment should be. The court then has to consider a number of factors.
I just don't see how it's different, because they've done the, alleged punishment ahead of time and then plead guilty. I know you're saying, well, the difference is there's a judgment, but we all agree the statute here doesn't require a judgment for it to be considered a conviction. So that can't be the dispositive difference, right?
Well, it doesn't require judgment, but it goes back to the definition of punitive punishment. I mean, the court would have to consider that community service that's being required of a defendant respondent before a PJC is entered as a punishment. And we're saying respectfully there's not enough in the record to indicate that was the court's intent. Certainly, we are arguing that was the court's attempt to have the defendant show that he warranted such consideration. Because again, a PJC is a benefit in that you don't have a criminal conviction. That's distinguishable from a time served situation where you actually do have a conviction on your record. And so when we say earning, and this is common language amongst North Carolina practitioners, is because one is trying to earn that benefit, not so much be punished or deterred from doing it again.
But even under that rubric, the judge has put a restraint on the individual's liberty, right? Presumably, this gentleman would not have performed community service had the court not said, because you are pleading guilty, you must perform this community service.
I think it's choice, Your Honor. I mean, to be very candid with you, this was not an order that if you don't do this, you won't get a PJC. It's if you want a PJC, you show me that you complied with community service. That's very different than a court order saying you must do this. So, and I think that goes to a difference, if you will. So,
Well,
a requirement.
it's like getting a benefit from a guilty plea, right? If he hadn't done that, the consequences would have been worse.
But the consequences would have been an entry of a judgment or a conviction. So what we're talking about here is someone who's requesting a benefit from the court. The court says, okay, in order to receive the benefit, you must do this. In this case, it was community service. This is not to say that the court said you must do community service. You are ordered to do community service, and then we'll come back and consider a PJC. Because the court did not do that. They did not order this defendant to do it to get a PJC. What happened, Your Honor, was that if the defendant wanted to receive a PJC, had to show proof that he complied with community service hours. And I think that is a key difference in the practice on how these PJCs are warranted. So there is no restriction on the defendant's liberty. A defendant can choose that I don't want a PJC, Your Honor. I'd rather have a judgment. And that's certainly a decision or prerogative of the defendant. Your Honor, I think that concludes my arguments and how I would make the distinction between receiving or doing community service prior to the entry of a judgment.
All right, you have some time in rebuttal. Thank you.
Okay, thank you.
Mr. Sines?
Good morning, Your Honors. May it please the Court, Rodolfo Sines for the U.S. Attorney General. Before getting to the substance of PJC and the procedure and how it works in North Carolina, I just wanted to start with the background of how the federal law immigration section is interpreted in this case. As this court has noted in Jaquez and the board has noted in matter of Mohammed, when Congress amended this section 1101A48A, and it created these two categories, the formal judgment of guilt and the deferred adjudication categories, it wanted to do away with the vagaries of state law. In other words, it didn't want the definition of conviction to depend simply upon the label that a state court applies. Taking that expansion into consideration, that's why courts like the Eighth Circuit, like the board in matter of Mohammed, have concluded that community service is sufficient to qualify as a conviction under the deferred adjudication second part of the INA. Here, when we employ the definition under Gonzalez, we can see why that the substance of North Carolina law fits within that broad expansion of deferred adjudication categories. Under state law in North Carolina, there's different kinds of PJC scenarios. The traditional true PJC scenario is where upon a plea of guilty, the judge then decides to continue the prayer for judgment to a later date. It suspends sentencing. There's no appeal rights during that period. It's basically put off for another day for a final judgment. But when there is a condition placed upon that continuation for prayer of judgment, North Carolina treats that scenario differently. It treats it as, in effect, a final judgment. And the reason for that is that because you are triggering the appeal right, the sentencing can the judge can no longer impose a sentence. So in effect, it's basically like a final judgment or a conviction. It just doesn't have that word or label in state law.
When is it a final judgment or conviction?
When the condition that's placed upon PJC qualifies as a punishment under state law. And
so, under your argument, timing doesn't matter at all.
Timing doesn't matter at all, Your Honor. What matters is the character of the order and whether it qualifies as a punishment under state law. And North Carolina has, as Judge Rushing alluded to earlier, already concluded that community service, among other things, can qualify as a punishment under state law. It also did so in an unpublished decision, the Baker decision. And so when we go back to Gonzalez, and we're looking to the substance of state procedure to discern whether it's a conviction under the INA, we're looking to that distinction between judge-imposed discretionary judgments that are getting at something that's proportionate to the crime, that can be discretionary in that sense, and the court-imposed mandatory administrative costs or compensatory orders. So in Gonzalez, for example, the court concluded that the Virginia statute, I believe it was.
And in the government's view, do we just need to apply Gonzalez as it is, or would we need to expand upon Gonzalez in some way to reach your argument?
It fits neatly within Gonzalez, Your Honor, and it's a continuation of what the board has said as well, that we don't look at the labels of what the state is saying. Here in North Carolina, there is no magic word of judgment or conviction. It's basically, and there's no further paper that's issued after this. It's just that after a plea of guilty, the court imposes conditions in order to receive the PJC. And under state law, that is the equivalent of a punishment. It's different, and it triggers a final order. There's no longer sentencing. There's no longer any sort of follow-up. The appeal can proceed in due course.
And do you agree that this new, well, it's not a new footnote, but it didn't make it into the briefs, that the conviction doesn't matter to the argument one way or the other?
It doesn't, Your Honor, because we're talking about a 2009 misdemeanor larceny offense. The other applicable conviction, which was conceded is not disputed as a conviction, is the 2013 misdemeanor larceny, same crime, same offense, just different dates.
Mhm.
So I think another helpful argument to make in this circumstance is looking not only to, for example, the matter of Mohammed case or this court's unpublished decision in the Gain, where it found a more restrictive INA provision about conviction, that community service satisfied that. But
If he didn't complete the community service just procedurally, what would have happened had he not completed it?
I tried looking into that, Your Honor. Based on my impression, it doesn't seem any different than like if he had received a sentence in a normal criminal case, in that there could be further consequences or further litigation on that. But I think it doesn't make a difference in terms of whether the order conditioning community service was a final judgment for state law purposes.
Yeah, I was trying to just figure out if he would go back and just be sentenced on, obviously not get the PJC and then be sentenced, because he's already pled guilty.
Right.
Yeah.
Right, and I was wondering that as well, but I think the Griffin case, that is the Supreme Court North Carolina case, it's pretty clear that no punishments can be imposed after a conditioned PJC order is made. So that seems to suggest that
So that
regardless.
didn't make any sense. So he could just not do the community service at all and nothing else would happen to him? Nothing else would happen?
I guess there could be different proceedings triggered at that point, but I'm merely
If I was the
speculating.
prosecutor, there would be different proceedings triggered at the point that he just didn't do the community service. That doesn't make sense.
I'm not fully sure, Your Honor, but what I do know is that it is still a final judgment and it triggers appeal.
Right.
The point I was going to make before was the habeas context is helpful here, albeit from different circuits. The Second Circuit and the Third Circuit have concluded that community service there is a restraint on liberty for habeas purposes, and the reasoning is because the person has to be in a certain place at a certain time. And so they have this obligation that the rest of society does not have to follow. And it's a very similar situation here with community service in the state criminal process, because the person is, again, having to do something that they don't normally have to do. If there are no further questions, I'll cede the remainder of my time.
All right, thank you very much, and we'll hear again from Mr. Johnson.
Your Honors, I'll be brief. This is a case of obligation versus preference. We've heard some conversations about obligating a defendant to do community service.
Can you answer a question I asked him earlier?
Yes.
I mean, just since you're more familiar with procedurally, if he doesn't complete the community service, he goes back and then is sentenced on the charge, right?
No, Your Honor. There is no sentence on the charge. If someone doesn't complete the community service, they will simply be, court will accept a guilty plea and issue a judgment or conviction and issue a sentence at that point in time. So what I'm explaining is that no sentence is issued when someone
Right.
is doing the community service to earn the PJC. It's timing. It happens before
But
sentence
when
is
the
actually.
community service is made a condition, is that appealable?
No, Judge.
Oh,
My
okay.
understanding is you cannot appeal that. Because once a PJC is entered, it's not a judgment that can be appealed. And so it goes back to obligation versus someone's decision. If the court says you're sentenced to 10 days and you must do 100 hours of community service, without question, that is a part of a judgment, and the person has a restriction on their liberty, and it's an obligation. This should be distinguished from someone saying that they're going to request the court enter a PJC, and the court saying, that upon us using our discretion, you must do this. And if you show us you did these things, we will then use our discretion to enter a PJC. And that's what I'm trying to explain as an important difference here. It's an obligation versus someone's preference to seek a PJC and make that request to the court. And so in this case, Your Honor, my client made a request to the court for a PJC. The court said, okay, we will consider entering a PJC upon showing that you've completed community service hours. That's distinguishable from having a judgment, a sentence, and then being forced to
I mean,
do community.
it just doesn't say that. It doesn't say considering prayer for judgment continued. It says prayer for judgment continued upon completion of community service work.
So
And North Carolina law, I mean, McDonald, Griffin, Pop, all of those say when a condition is imposed that amounts to punishment on the continuation, then that becomes a judgment.
Judge, my reading of that particular case is my client had no further court dates, no further dates that he had to show compliance with community service. So my reading of it is that he had to show compliance before the court entered the PJC. In other words, there's nothing in the record to suggest that once the court issued the PJC and required the community service, that my client had to return with proof as subsequent to the court entering that. My understanding is that once the court
Well, if
entered...
anything, that suggests that the court already entered the prayer for judgment
Correct,
continued.
correct.
It's not what you were saying earlier. The court considered doing it and said, I might do it later if you do this community service.
Well, I considered it, even in our brief, that it's a condition precedent. So it's if you want to receive it, you must show us that you complied with community service. And my understanding is that once he complied with community service, the court then issued the PJC. It's not
So
that...
when he, because it's not in, but does he, on the community service, is there a certain, number of hours that the court suggested he do? Or is the court
Yes,
clear
Judge.
where he's to do community service?
It's up to the discretion of the courts, and it varies. Some judges may have you do it at a local nonprofit. Some judges will have you do it at a certified nonprofit that works with the courts.
But the court decides where the community service is done and how many hours of the community service.
Correct. If there's no further questions, thank you, Your Honors.
All right, thank you. We appreciate the arguments of both counsel. We'll come down and greet counsel and proceed.
corporate affiliates don't make loans at all. They've never made loans, as alleged in those complaints. Some of those corporate affiliates did not exist during the time period covered by the order to show cause. So there are significant factual differences between the corporate affiliates at issue in each of those underlying lawsuits. Continuing on the issue preclusion issue, Your Honors, the controlling facts changed between the earlier decisions and the district court's decisions. In particular, the Northern District of Texas and the Middle District of Pennsylvania did not have before them the decision that was issued by the commission after those decisions were rendered. In the commission's decision, the commission expressly declined to issue any kind of final order that would have adjudicated Title Max of South Carolina, Inc.'s personal jurisdiction constitutional defense in advance of an evidentiary hearing on the merits. What does that mean? It means that Title Max of South Carolina, Inc. was pulled into an administrative tribunal in Harrisburg, Pennsylvania, forced to sit through an evidentiary hearing before any adjudicator had finally adjudicated whether it had personal jurisdiction or could exercise personal jurisdiction over Title Max of South Carolina, Inc. Again, an entity that does business in South Carolina under the laws of South Carolina, 6 states away from Pennsylvania. As to the second error by the district court when it came to issue preclusion, the district court held that Title Max of South Carolina, Inc. was in privity or was adequately represented by the prior litigating entities. And that was an error on several fronts. One, the district court applied a less stringent standard than actually applies in the Fourth Circuit to conclude that Title Max of South Carolina was adequately represented in those prior suits. Two, the district court relied on the fact that Title Max of South Carolina had the same counsel as the prior litigating entities to conclude that Title Max of South Carolina was adequately represented in those prior lawsuits. And choice of counsel simply does not privity make. This court has been very clear that it applies a stringent standard to find adequate representation, also known as virtual representation. And that stringent standard requires proof in the record, something in the record that the district court can rely upon to conclude that Title Max of South Carolina, in this situation, controlled the prior litigation, that they literally were controlling that prior litigation and directing it. Or two, that Title Max of South Carolina was closely affiliated with those other entities. And to be clear, Title Max of South Carolina, Inc., what is in the record is that Title Max of South Carolina, Inc. is a subsidiary. It has no other subsidiaries. There's no world in which a subsidiary can control the litigation of its parent company or its sister subsidiaries. And worse, there is nothing in the record that would allow the district court to draw that conclusion. And, Your Honors, I think this is important because we allow that virtual representation prong of privity to expand, and it will close the courthouse doors to many litigants who have legitimate claims that need to be heard based on the facts applicable to those parties. And before I move off that topic, Your Honors, I do want to direct you to the fact that the Middle District of Pennsylvania declined to apply issue preclusion, even though that argument was made in front of the Middle District of Pennsylvania, Judge Wilson as well. Your Honors, at this time I'd like to move to Younger abstention unless there are any further questions on collateral estoppel. Younger abstention is the exception, not the rule. Under Younger, Younger is a departure from the general rule that federal court has a virtually unflagging obligation to take its jurisdiction where it exists. As a result, a multifaceted test must be met. The party invoking Younger must show on a claim-by-claim basis that the challenged conduct is a civil enforcement proceeding that is ongoing. And then the party has to show that each of the Middlesex factors are met, including that the state proceeding is intended to protect important state interests, that the state proceeding offers an adequate opportunity for the federal plaintiff's constitutional claims to be adjudicated, and that the proceeding has been initiated by proper service and is therefore ongoing. Starting out with the first issue, whether there is a civil enforcement proceeding ongoing as to each of Title Max of South Carolina's claims. There is not as to several of those claims. One, Title Max of South Carolina, Inc. challenges a subpoena that was issued in 2024. Two, Title Max of South Carolina, Inc. challenges any future regulatory efforts that the Commission may choose to take in the future. Neither of those actions are currently ongoing. In fact, the subpoena is not an enforcement action at all. And several courts, including the First, Third, and Fifth Circuit, have reached the conclusion that Younger simply does not apply to a subpoena. As to future regulatory activities, there's also no question that Younger cannot apply because there is no pending regulatory activity when it comes to the time period 2017 to the present.
Would the solution there be to, I know you talk about this in your ripeness section, to correct the judgment so that those two dismissals are without prejudice? We've addressed this complication of potentially assume that the order to show cause was abstention was proper on that. When you have a claim on which abstention is proper and one on which it isn't proper, we've suggested maybe the solution is to replead so that only the claims that are properly in front of the court could proceed.
Yes, Your Honor. If the court is inclined to correct any application of Younger to the 2024 subpoena and future regulatory efforts, I actually believe the proper course would be to remand so that Title Max South Carolina can continue to litigate those claims. You know, I know there is a ripeness argument, which I'm happy to discuss.
You probably need to do that at some point. I don't want to get you off track.
Yes. So the primary response that we've heard on the future regulatory efforts in the 2024 subpoena is that those challenges aren't yet ripe. Your Honors, respectfully, they're as ripe as they can be. We know for a fact that the Department has in the past enforced a subpoena against Title Max of South Carolina, Inc., and we know that that subpoena led to an enforcement action. There's no question that the moment there is no longer federal oversight over its conduct, that the Department is going to go to court and seek to enforce that 2024 subpoena. In SBA list, the Supreme Court recognized that prior conduct by a regulator can be evidence of imminent threat of enforcement.
Well, the rationale in these cases about non-self-executing subpoenas seems to be not that the court has no reason to think there's a threat of prosecution, but rather that a subpoena is an investigatory device, and the government may not find anything to prosecute, right, or to bring an enforcement action about, and that when a court order is then sought to enforce the subpoena, then once that party is in court, they can bring all of their objections then when they are ripe, when a court's enforcing that. Now, if you're challenging the subpoena itself, right, the subpoena itself violates the First Amendment, something like that, that's maybe a different question. But here the challenge seems to be eventually if the state enforces its laws against us, that's going to violate the Constitution. And that is what seems to not be ripe, or what the court thought was not ripe in this non-self-executing subpoena context.
Yes, Your Honor, and the Supreme Court is actively considering a case that touches on this exact issue, you know, First Women's Choice, which is currently pending. I took a look at Nick recently, which recognizes that if you cannot bring a pre-enforcement challenge to a state investigative subpoena, you're left in a catch-22, and this is always the problem with Younger, right? You're left in a catch-22. If you can't go to court when you get that subpoena, but before it's been enforced, then you have to wait until that enforcement proceeding is brought in state court. And the moment it's brought in state court, you're liable to get a judgment quicker in state court than you would in federal court. And that state court judgment is going to have preclusive effect in federal court, basically stamping out the federal court's ability to adjudicate an imminent constitutional injury. And that is really the purpose of Section 1983, is to provide an immediate federal forum for a threatened constitutional violation. And that's what we have when we're facing a subpoena that it hasn't been enforced yet, admittedly, but could be any day, will be any day, right?
Did Title Max of South Carolina change its conduct somewhat between the 2017 subpoena and the 2024 subpoena?
Yes, some of its business practices were changed after 2017. And actually, Your Honor, I think that demonstrates that any adjudication on the applicability or enforceability, constitutionality of the 2024 subpoena would not necessarily control the outcome of the pending order to show cause proceeding, because facts have changed, and it could have an impact, but it will not control the outcome of that proceeding, which I think also means the 2024 subpoena is not. The challenge to the 2024 subpoena is not subject to Younger for that reason.
Do you want us to hold this for first choice?
Your Honor, I think if I were you, I would probably do that, and I think that would be the correct thing to do under the circumstances, given the possibility that first choice weighs on the rightness of a challenge to a pre-enforcement subpoena issued by a state agency. I don't think it's necessarily going to be determinative, but I think that it could have a significant impact on the reasoning here, and a lot of the same issues that we've raised on the rightness point are briefed there. Your Honors, I'm low on time here,
But you do have some time in rebuttal.
yes,
Thank you.
thank you.
And we'll hear from Mr. Pratt now.
Good morning, Your Honors. May it please the Court. I'm Michael Pratt with Greenberg Trard, representing the Secretary of the Pennsylvania Department of Banking and Securities. Before I respond to some of these arguments, I just wanted to an update on where the state proceeding is right now might be helpful. In our briefs, we did identify, I think both sets of brief, that the merits hearing, the administrative merits hearing, has taken place and has concluded. As of Monday, this past Monday, all of the post-hearing briefing has been completed. So it's now pending, decisions pending before the hearing examiner. In addition, Title Max of South Carolina, as well as all the other 7 affiliates, filed a motion to dismiss in the administrative proceedings, arguing that the state had no personal jurisdiction over any of them. That was denied by the hearing examiner. So it was heard. Now there's some arguments about the commission final adjudication. I'll get to that. But where we are now is Title Max has appealed, Title Max South Carolina and others has appealed to the Commonwealth Court of Pennsylvania. And their argument is that the commission has denied their motion to dismiss. And therefore, and that was wrong, and therefore the Commonwealth Court should overturn that decision. That has been argued, and it is now pending before the Commonwealth Court. So those are the facts. And then, we've been involved in this litigation.
And then how do all those facts that you just told us impact what we're doing?
Because, Your Honor, there has been a lot of argument that they have not had an adequate opportunity to have their constitutional claims heard. Number one is a factual matter they have. But secondly, they're also arguing that somehow Younger stands for the proposition that it is not adequate unless their constitutional or their personal jurisdiction questions are finally, whatever that means, resolved before a merits hearing. There is no Younger standard. I've scoured the universe for a case that says that's the standard. What the standard is that they have the opportunity to raise those constitutional claims in the state proceeding, including on judicial review. That's why it's relevant, because they've done that. but younger doesn't stand for that proposition anyway. And you know, we've heard throughout these 6 cases, these words used, extraterritoriality, regulatory overreach, targeted. The issue before it has nothing to do with those points. The issue here is pretty simple. The dispositive issue is pretty simple. And that is, under our system of federalism, which forum is the right forum to hear the plaintiff's dispute? That's what that's all Younger stands for, and that's the way the district court has applied it, and every other district court and court of appeals has applied it and found that the correct forum is Pennsylvania, because they filed it first and it's an ongoing proceeding. So there are really only 2, as far as Younger is concerned. By the way, before I even get to that, let me go, if I could go to the preclusion issue, because there's been some discussion about that. And I will go to this question about adequate virtual representation. The fact is, Your Honor, the law that they're relying on, the Fourth Circuit case they're relying on, is not good law anymore.
Well, can I ask you about, because that part of the preclusion ruling troubled me some. The district court seemed to rely on the fact that the lawsuits seemed coordinated, same counsel, same timing, and that all of these are Title Max affiliates somehow. And so therefore, because a Title Max affiliate in Texas had brought a lawsuit raising these same claims and had lost, that therefore Title Max of South Carolina was precluded and was bound by that judgment and precluded from bringing those claims itself in its own lawsuit. And I'm having trouble squaring that with the pretty high standard the Supreme Court has set for binding a non-party under issue preclusion.
Well, Your Honor, that virtual representation high standard that they're referring to is no longer good law. There is a high standard.
Taylor versus Sturgill is good law, right?
Absolutely.
Okay.
Taylor versus Sturgill is the law which was cited. And in fact, Taylor versus Sturgis was cited in the Fourth Circuit in a couple of other more recent cases. They don't cite the Madison cases.
Well, how does this case satisfy that standard?
It satisfies it because what Sturgill said is there's 6 different categories by which a non-party can be bound by a prior case. One of those categories is that it says non-party preclusion may be justified based on pre-existing substantive legal relationships. That's all the district court was saying. Now, they didn't use that language, but the fact is there is no dispute that there is a wide-ranging substantive legal relationship between all of these parties. They are owned by the same person. They have coordinated this.
I thought the court in that case rejected a sort of loose, vague definition of what it means to be related enough. I mean, they said control, if one entity controls the other or controlled the litigation, or what maybe if the court in the case that's being used to preclude, if that court recognized that this third party was implicated and that and made sure that their rights were protected, you know, all of these set a very high bar for making sure that the third party's interests are protected, not just, well, they're all kind of subsidiaries of the same parent, and so close enough.
With all due respect, y'all, we may read the case differently.
I was just like
when I'm
quoting the
reading
words of it.
Taylor v. Sturgill, as I read Taylor v. Sturgill, these were all separate and independent bases upon which, you're right, but that's a separate ground. One ground is whether there's a substantial legal relationship. That's one ground as whether a non-party is bound. Secondly, there is another ground if they have been adequately represented by another. There's another ground. Did the other party control the litigation?
So you're saying a substantial legal relationship is that they're both subsidiaries of the same parent?
No, Your Honor. It is a factual determination, but it's a substantial legal relationship there's a close relationship between all of these parties. Every court, I mean,
What is the relationship? And what is the
relationship
case
is
finding that that is sufficient?
well, first of all, Your Honor, every court has looked at this, has determined that, because they are the same business, they have the same address, place of business address. They have the same, they're owned by the same person. They have coordinated litigation. There's no question about that. They have, well, there are, a whole host of facts. But they've won the parent company. They've won parent company. In fact, we don't even know all the ways that they're integrated. But
That
they
may be the
clearly are
problem,
owned
because
by the same person.
in the district
Right,
court's ruling, I didn't see findings that would establish this sort of close, close is not even the word, right? This sort of legal relationship where we can assume that one party's interests were protected when a different party was litigating. It's not enough to say, well, they use the same post office box and have the same parent. And that seems to be what you're saying.
Yeah, well, what I'm saying is, John, there are a whole host of facts. Yes, one is that they do the same business. They're connected to the same they're connected to the same parent company. They are owned by the same person. Their own law firm. They're the same law firm. But I'll even go back further, if we could, Your Honor, to show this. Even back in 2017, when this subpoena was issued, they responded together to that subpoena. One entity responded to that subpoena on behalf of all of them, including this
Well,
one.
wasn't it sent to only one place and it just like listed a bunch of entities and non-entities on the subpoena?
So true, Your Honor. But if they were separate and independent, they could have done that. There was a
I
central
mean, the law sets a
company.
pretty high bar for us to find that separate entities are in fact the same entity.
Your Honor, well, first of all, I agree that there's a high bar, but I think that I don't know how else to explain that there are, and with the district court file, there's no
Well,
relationship.
what do you think is
that
the strongest case to
Right.
support your argument that the scenario we have here shows that these entities are sufficiently related?
Well, Your Honor, oh gosh, there are a series of cases we've cited in our brief.
Which do you
And-
like the best?
Oh gosh. Which do I like the best?
Give me one that you think strongly supports, and I think that's what Judge Rushing has been trying to get at as well. Well, you have been getting at it, Judge Rushing. I'm just trying to get a response.
Gosh, Your Honor, if I could, and my apologies, the only reason I haven't is because there have been a number of them that were cited in our briefs. I honestly, the substantial legal relationship, these affiliate relationships, they have admitted that
Is there a
there's,
Supreme Court case that you rely on?
no, there isn't.
Okay,
There
is
isn't,
there
Your Honor.
let's narrow it down
Yeah.
here. Is there a Fourth Circuit case?
There is
that-
not a Fourth Circuit
Okay.
case we're relying on.
Is there a Third Circuit case that you're relying on,
We're
since
relying
this is
on
Pennsylvania?
the District Court, we're relying on Third Circuit cases, we're relying on
And
Fifth
we
Circuit
get-
cases.
and- okay,
we're
which
relying on
Third Circuit
First
case?
Circuit cases, I'd have to pull them up. Your
Oh,
Honor.
okay.
Okay, I have no problem doing that, but I can rest on our briefs that there are a series of cases that we have cited for the proposition that there's a substantive legal relationship between all of these parties. That's what it means. There has never been a dispute about that
No, my question,
by anyone, but even by them. that they have-
counsel,
Yeah, I'm sorry, go ahead, Your Honor.
my question, and I think Judge Thacker's question is about, is there a case saying that this sort of relationship
Yes.
suffices for issue preclusion?
Right.
There have, for privity purposes, yes, for establishing privity, there are a series of cases that cite that. But, Your Honor, even if, and I know we're spending a lot of time on issue preclusion, but even aside from issue preclusion, because I don't want to miss all my time, just independently, this court, the district court also ruled that it just simply doesn't satisfy the Younger standard here. That number one, and there are only two serious points that they raise. One is that somehow there's no sufficient state interest under Middlesex. And the second, which we talked about somewhat, was that there has been no adequate opportunity to raise their constitutional issues in the state court. The fact is, Your Honor, that, and they're relying on the case Harper, Fourth Circuit case. All Harper did, Harper was a very unique case in that Harper was dealt with a statute which on its face discriminated against out-of-state waste haulers. That is not what's going on here. And in fact, Your Honor, that was 2005.
I mean, the statute may not have discriminated on its face, but we had a prior Fourth Circuit decision saying that that statute or a statute very similar was a dormant commerce clause violation.
Absolutely,
right?
but that's not what's going on here. We're not talking about a statute that is unconstitutional. That's not the issue here. The issue here is that they don't want any, with the Pennsylvania Department of Banking said, we are regulating whether these companies have come into Pennsylvania, have reached into Pennsylvania and violate our usury statute. It's not a facial challenge. It's a factual challenge. That is what is difference. The second point I will make is this, because just a few years ago, the Supreme Court, overriding, Younger stands for the proposition that all you need to establish is that there's an important state interest. And there is an important state interest. The Third Circuit has established that. Other courts in regulating and their police power in this field. And I'll point this case out to you. In National Pork Producers, U.S. Supreme Court case, in 2023, they rejected this idea that somehow the courts, that there is a per se rule where just claiming Commerce Clause somehow overrides a state's police powers. In fact, I'll even read a sentence here. It says, this court has never before claimed so much ground for judicial supremacy under the banner of the Dormant Clause, of the Dormant Commerce Clause.
What do we do about Harper? It's the one difference between this case and the ones in Pennsylvania and Texas. And, there's pork producers and other cases on the merits of the Dormant Commerce Clause challenge. But does Harper ask us, are we supposed to look at the merits, kind of take a peek and see whether this seems like a legit Commerce Clause claim? Or is the fact of pleading a Commerce Clause challenge enough? Or what's your suggestion for how Harper applies in other Commerce Clause cases?
Well, Your Honor, first of all, I think the Supreme Court has made it clear that the Commerce Clause, just pleading a Commerce Clause claim is not enough. We are talking about a different standard, and that is what is sufficient for Younger abstention. The Harper is a unique case.
Right.
It's unique, 2005.
I guess my question
that
is,
we're not talking about statute.
I'm trying to
Go ahead.
Oh, I'm
figure-
sorry, go ahead, John.
I'm trying to figure out,
Yeah.
so Harper says
Right.
that the plaintiffs there had pled a Commerce Clause challenge, and Harper said under Middlesex Factor 2, this is such a unique federal interest, this Dormant Commerce Clause issue is such a uniquely federal interest that it diminishes the state interest, and therefore abstention is not appropriate. And I'm trying to figure out, how do we apply Harper to other cases raising Dormant Commerce Clause challenges? Is your reading of Harper that we just look at what has been pled? Do we take a peek at the merits? How do we handle that?
I think Harper is very narrow. Harper says it. It's because on its face, this is a statute that discriminates against out-of-state workers. On its face. So it wasn't what they pled, it was the statute itself. It's a legal matter. We're looking at the statute. There's no factual determination. There is a legal determination based on what was pled. That's what makes it unique. And there's no other case out there that even stands for this proposition. Remember, this was 2005. It was before that the Sprint decision was even issued. And so today, under this standard, it simply doesn't apply here because these are different types of cases. Yes, so I would contend that yes, if there is a statute which on its face that the court could look at and determine that it is discriminating against out-of-state folks and impedes interstate commerce, that's the difference. And that's the only difference. Otherwise, the only fact that the court should look at in terms of extension is whether there is a strong state interest in the matter. And there is a strong state interest. Nobody's arguing that. What's being argued here is for the first time that somehow just pleading a commerce clause claim somehow overrides the state interest. The U.S. court has made it clear that is not enough. So I hope I've answered your question.
I appreciate it.
Okay. That's what. The second is whether there's an adequate opportunity. I have already said, I've read that there's no case that says that there needs to be a decision in a state court. Now, federal court's a different issue. That a state's procedures have to decide an issue on the merits, personal jurisdiction question before you reach the merits. But here, the fact is, it was raised, it was heard, they tried to send it to the commission. They have taken the position that is the final decision in their appeal to the Commerce Court. So as a factual matter, Younger simply, the district court was right in abstaining alternatively. Preclusion, Your Honor, I won't go down that road again. The only other points I'll make real quick, Your Honor, is that the 2024 subpoena, it wasn't ripe. It's not ripe. It's not ripe. It was not. It's very different from those other set of cases that involve First Amendment restraints on speech, including the U.S. Supreme Court case that is pending.
Can I ask you a question about subpoena? I realize you're over your time,
Sure.
but the subpoena says, it has a warning about if you don't comply, you may subject you to penalties as provided by law. Mm-hmm. Are there penalties for not complying with the 2024 subpoena?
No, Your
Right.
Honor.
So that's a prediction of like future
all
proceedings
this
and
is
future
speculative,
penalties.
Your Honor. They may or may not enforce it. There's no threat of enforcement.
Well, I'm just asking because if
no.
a subpoena comes with penalties, then it doesn't qualify as non-self-executing, and we have a different question.
No, it does not come with penalties until there's they
Okay.
seek to enforce it. In fact, that's what happened in 2017.
Do you have any other questions?
And he litigated for years.
Do you have any questions? All right,
Okay.
thank you.
Thank you, Your Honor.
Your Honors, I have a number of things to cover here. Let me just start out by saying that I do disagree with some of the facts that Mr. Pratt just recited, and I think actually the factual differences that we have actually demonstrate why the district court should have developed a more complete record before applying issue preclusion in this case. The district court simply did not have enough facts in front of it to conclude that issue preclusion applies. Second, I'd just like to bring the court's attention to Dewberry, which is consistent with the fundamental principle that corporate entities are to be treated separately if they're incorporated separately. Dewberry says, if corporate law treated all affiliated companies as a single corporate entity, there could be reason to construe the term defendant in the same vein. But the usual rule is the opposite. It is long settled as a matter of American corporate law that separately incorporated organizations are separate legal units with distinct legal rights and obligations. In order to find otherwise, there has to either be veil piercing or a finding of privity based on a more complete record than the district court had before it in this case. Third, Your Honors, I'd like to address the subpoena. As Judge Rushing pointed out, the subpoena does come with a official seal from the Commonwealth of Pennsylvania, and it looks really serious, and it says investigative subpoena at the top, and it says if you don't comply with this, there could be penalties under law, and it says that the Department of Banking Securities has the power to enforce these laws and to require people to produce documents. And that was sent to an entity 6 states away, 500 miles away. You know, if these state regulators are just sending out these subpoenas, and it turns out there is actually no enforcement power behind them unless they're brought to court, you know, what kind of message does that send? The message it sends to people is, you know, think about less sophisticated parties who may receive a subpoena like this, right? They receive a subpoena that has an official seal on it from the government, okay? And then they're told they can't go challenge it in court. They can't go challenge it as a violation of their constitutional rights. You know, they're literally left in limbo, which is what Telco says not to let happen in the younger context. Now I'd like to move on to Harper, and there's a lot of interesting case law in that Harper decision. I think it's very well written. I think it's undergirded by structural constitutional concerns, right? Younger is motivated by comity and federalism. Those motivations are literally turned on their head when a party pleads a Commerce Clause claim, particularly a Commerce Clause claim that is as meritorious as the one that we have pleaded. We have Midwest Auto Loans on our side. We have Carolina Trucks on our side. We have Frosch on our side. Frosch and Carolina Trucks are Fourth Circuit cases. So if the court does want to take a peek at the merits, it will see we have a very meritorious claim.
What do you think we do with Harper? Is that what we do? I mean, obviously, just pleading Commerce Clause is not enough. If anything, your argument is a little bit more about due process, personal jurisdiction, than it is about discriminating against outsiders. I mean, the whole problem here is Pennsylvania's treating an outsider just like it treats insiders. But do we look at the merits? That seems to not be what Younger is about, but just pleading this constitutional provision also seems insufficient. So what do we do with Harper?
Your Honor, I'll start by pointing out what the Secretary has already conceded in her answering brief, pages 50 to 51 and page 55, that the purported merit or lack of merit of appellant's Commerce Clause claim is completely irrelevant to the abstention analysis. We're willing to endorse that view for purposes of this case. They've conceded it, that it does appear to be what Harper says. We've pled a Commerce Clause claim. I think you can stop there. But I will say, if you don't want to...
So you think it's sufficient just to plead the Commerce Clause claim?
And
that puts you, and that takes care of the Younger abstention?
Yes, Your Honor. I think if you have a facial Commerce Clause claim, which is literally what Harper says, then under existing Fourth Circuit precedent, then that takes you into federal court. And there's good reason for that, right? Because a federal court is the proper forum to adjudicate what is essentially a dispute between sister states, sister sovereigns in our union. And that is exactly what the framers intended, as Harper points out. The Constitution entrusts the federal courts with oversight over Commerce Clause disputes. So
in Judge Wilkinson's opinion, he relies and discusses metagene. Why would he discuss that?
I'm sorry.
I think it's pronounced metagene. In Harper, Judge
Yes.
Wilkinson relies on metagene. Why would he talk so much about that if it's just what you're saying here today is that you just pleaded and then you're in federal court?
Your Honor, I think it's partially because the abstention analysis necessarily requires a look at the pleading that's in front of you. It's at the 12B6 stage, right? I mean, if the court wants to investigate the merits of a Commerce Clause claim, that necessarily requires additional briefing, which I think is proper here on remand to go back and brief this meritorious Commerce Clause claim. Again, in this particular case, there's no question. Go
Against
ahead.
the whole spirit of the younger extension?
Uh,
If we have to go in and look at the merits of the Commerce Clause?
Yeah, that's exactly right, and that's why I don't believe you have to do that to determine whether younger applies. But in this particular case, I think that we are entitled to litigate the merits of the Commerce Clause claim because younger should not apply, consistent with Harper.
Do you have any other questions? Do you have any other questions? All right, you're out of time. Would you like to wrap up in 30 seconds?
Yes, Your Honors. I'd just like to conclude by noting that we do have a bad faith exception claim, and I think that's an important part of our claim here, particularly when it comes to adequate opportunity. The court should reverse and remand the district court's opinion because collateral estoppel did not apply, and the court improperly abstained under the Younger doctrine.
All right, thank you. We'll come down and greet counsel, and then we're going to take a brief recess before we finish our final two cases.
Honors, and may it please the Court. David Irola on behalf of Appellant Xavier Holly, and I'm joined by my colleagues Ms. Fierst and Mr. Young. Your Honors, we have two main arguments today. The first, which I'll address, relates to a series of errors that the District Court made when calculating Mr. Holly's sentence. These errors, in the aggregate, call into question the validity of the punishment imposed in this case. The second argument, as you heard from my colleague Mr. Young in a moment, is that Mr. Holly's trial counsel was clearly conflicted, which undermined the integrity of the proceedings and the representation that Mr. Holly received in this case. The Hobbs Act imposes a 20-year maximum sentence for anyone who by robbery or extortion obstructs, delays, or affects interstate commerce or, quote, attempts or conspires so to do. The question here is one of statutory construction. When someone is convicted of both conspiracy and attempt under the Hobbs Act, as Mr. Holly was here, can the court double the penalties when those offenses are based on the same underlying conduct, directed towards the same object, and ultimately produce the same harm? The answer lies in a Supreme Court case in Prince, which says that the question comes down to Congress's intent.
I thought in your reply brief, your argument had changed to be that the district court abused its discretion by imposing consecutive sentences. We decided the question you just posed in Oliver, right? That conspiracy and attempt can both be punished as a matter of statute and constitutional law.
Your Honor, we would submit that Oliver is distinguishable from this case both on the law and the facts. In Oliver, it is true that the court upheld the imposition of a consecutive sentence for a defendant that was convicted of both conspiracy and attempt under the Hobbs Act. The court did not have an occasion to consider, as part of that case, in part because the arguments weren't advanced by counsel, whether Prince and some of the other authorities that we cite in our brief warn against or prohibit the imposition of consecutive punishments.
I didn't see a double jeopardy argument in your brief. Are you making a constitutional argument?
Your Honor, we're not contesting that attempt and conspiracy are separate offenses under the Blockberger test. We concede, of course, that each of them requires proof of a fact that the other does not. The issue
this
here
argument against consecutive sentences, was that made at the district court?
Your Honor, at resentencing in 2024, counsel did argue against the imposition of consecutive sentences by reference to 18 U.S.C. 3584. The issue of Prince and some of the other things I am discussing did not come up at resentencing.
Okay, so the arguments you're making now were not made before the district court?
I think there's overlap between the arguments that I'm making now and the arguments made in court. They did specifically in their position paper. Trial counsel did object to the imposition of consecutive sentences and argued that Mr. Holly ultimately should receive the statutory maximum of 20 years. That's consistent with what we believe is the appropriate punishment here. I want to go back, Your Honor, just to Oliver briefly, because I want to acknowledge that that is a recent decision where consecutive sentences were upheld. As I said, Oliver did not engage with the question of whether applying this framework in Prince, consecutive sentences would have been barred. Oliver is also distinguishable on its facts. In Oliver, the factual predicate for the conspiracy and attempts involved over a year of planning in the lead up to the robbery that ultimately occurred.
So when you keep saying Prince, so your argument has to be that Congress did not authorize subsequent punishments for conspiracy and attempt.
As it relates
That's a
to
statutory interpretation argument. And where do I look in your brief for your analysis of the statute so we would understand that Congress doesn't authorize this?
Your Honor, it's covered in our opening brief. I don't believe it's addressed to the same extent in the reply brief, but it is in, I believe, the second section of our opening brief.
And you think Oliver did not address whether Congress authorized a consecutive sentence for conspiracy and the separate offense of attempt?
No, I think much of the reasoning in Oliver was around whether conspiracy could be considered distinct from the attempt, and the reasoning, at least as came out during oral argument in that case, was because they were not contemporaneous, the conduct that gave rise to the conspiracy and the attempt was just one part of a larger conspiracy that had conduct spanning over a year. The court seemed to ground their decision in that fact, as well as the fact that in upholding the imposition of consecutive sentences, the court made much of the fact that Oliver had an extensive criminal history. He was a career criminal, 27 prior convictions, I think 7 of which were felonies, numerous BOP disciplinary infractions. Those were all cited as aggravating factors in the court's opinion in Oliver. that they believe warranted or at least supported the district court's decision to impose a consecutive sentence. We don't have that same fact pattern here. We have a conspiracy that played out over the course of, at best, 48 hours, involving our client, Mr. Holly, who was 18 years old at the time of the offense.
So this is an argument about discretion under 3553A, right?
Yes,
This
Your
is
Honor.
not an argument that Congress didn't authorize anyone to ever get consecutive sentences.
Yes, Your Honor. I'm simply trying to distinguish the facts of Oliver from our own, because I think there is an underlying theme in both Oliver and other cases where the court has upheld the imposition of a consecutive sentence. I think many of those cases are distinguishable in their facts, or they're distinguishable
Don't the
because...
guidelines tell the district court to make these sentences consecutive? I thought the guidelines say if you don't reach the guidelines recommended sentence, then you should run the sentences consecutive until you reach the guideline sentence.
Your Honor, that is correct. That's in Section 5G 1.2. It does say that, and as our briefs argue, that is very much in tension with not only other provisions of the sentencing guidelines, but also certain federal sentencing laws.
You didn't bring a challenge to that provision of the guidelines as somehow against the law, invalid, unconstitutional, anything like that.
Our argument is that it's inconsistent with several parts of federal sentencing law and the guidelines,
Do you
including...
have an argument about the grouping, or is that going to be your co-counsel?
We do have arguments about grouping, and I'm happy to turn to those now.
Yeah, because you don't have much time left. And I have a question about grouping. Wasn't the total offense level the same regardless of whether they were grouped or not?
Your Honor, it's correct that had these counts been grouped in a single group rather than two groups as they were by the district court, the offense level would have been the same. We don't think that that's the end of the analysis. The court here, the standard for harmlessness is that the court makes clear on the record that it would have imposed the same sentence regardless of its ruling on the issue, even if it had ruled in our favor. I don't think the court makes an explicit statement to that effect, but I'd also just step back a level and say
But you
that...
did explicitly acknowledge that the grouping did not affect the offense level. The district court did.
Yes, Your Honor, we concede the offense level would have remained the same whether these were two groups or one group, as we are arguing for.
And isn't an offense level of 45 already off the chart?
You're right, the guidelines range goes up to 43, so due to
Right.
a prior obstruction, he was at 45. One more point I want to make on the grouping with my remaining time, as I see I'm getting close here, is the whole purpose of Section 3 of the guidelines, which addresses grouping, is in large part to prevent the imposition of multiple punishment for the same substantial underlying conduct. And that's, in fact, what we submit was the case here. So, yes, there is this prerogative to follow 5G 1.2 and stack the sentences, but that very much does violence and is in tension with not only other provisions of the guidelines, but federal sentencing law. I see I'm at time, Your Honor.
All right, thank you.
Thank you.
We'll hear from Mr. Young.
Thank you, Your Honors. May it please the court. In the sentencing proceedings in this case, Mr. Hawley's counsel had an actual conflict that adversely affected his representation of Mr. Hawley at sentencing. Under Kyler v. Sullivan, this court, the Supreme Court, said that all you need to show an actual conflict, and then you have to show that that conflict adversely affected the representation at sentencing. There was an actual conflict at sentencing in this case. Need only start at the January 10th, 2024 hearing. Mr. Proteguru shows up at that hearing, says he just spoke with his counsel, with his client, who he hadn't spoken to in months. His client had been doing research and wanted to raise an issue that Hawley's counsel had actually missed at trial. That is, he didn't impeach one of the government's key witnesses about the fact that Mr. Hawley had been in custody for a separate offense at the time that the government's key witness said that he had spoken to him about keeping the gun in the case. And what did Mr. Proteguru think about this issue? When we talk about what's an actual conflict, what matters is...
But he wasn't in custody that entire day, correct?
Yes, Your Honor. He wasn't in custody in the morning. The records show that he was at least in custody at 1:40 p.m. in the afternoon, and he was in custody at least until around 10:15 in the evening. So there's a huge chunk of time where he was not able to communicate with Mr. Murray. And so the issue
And
is...
a huge chunk of time where he was.
Yes, Your Honor. I think the important issue here is not whether or not the cross-examination would have been perfect. at the trial court, looking back 12 years later, is it something that counsel missed? But even more importantly, did Hawley's counsel think that he had missed something where he felt like he had a conflict that was impairing his representation?
I guess I'm trying to understand your conflict issue here because of it being a resentencing. So the district court judge is aware, even though he did not cross-examine him as to this issue during the trial. Now we're at resentencing. The district court judge is aware of this issue. I'm just trying to understand how this relates to the actual resentencing before the district court.
Right, so my understanding of the record is that Mr. Hawley had been doing his own research, looked at the PSR, reminded his counsel right before, on the eve of sentencing was supposed to happen January 10th, hey, you were my trial counsel. I was in jail at the time that this guy says that we spoke about keeping the gun. And this relates to count 2, the attempt offense that he was convicted of. Hawley's counsel shows up at the sentencing on January 10th at what was supposed to be a sentencing hearing. He's asking for a continuance. He says, Your Honor, this is something that I completely missed at trial.
But it's a motion for new trial, right? And that's different from the sentencing.
At
And the
this-
district court said you should have, he requested, can I have new counsel, different counsel for my motion for new trial? Fine to go ahead with the sentencing. And the court said, that sounds like a plan. We don't even have a proper motion in front of us. So we'll move ahead with the sentencing because there's no conflict there. And you can have new, different counsel for your motion for new trial later. So that's where we are. What's wrong with that?
Well, first of all, that all happened after his counsel had already been conflicted as of January. That all happened at that sentencing hearing, April 18th. Mr. Hawley, acting pro se at that point because he had been informed by his counsel, I can't represent you on those issues, did package his argument.
But this is the sentencing. How did any of that impact the sentencing and a resentencing at that?
Right. The resentencing spans from January to April because how did it impact?
But what did it matter?
It mattered-
What did it matter at
Sure.
the sentencing?
One of the key issues that, if you read the transcript from sentencing, one of the key issues that the trial court, the district judge, relied on in differentiating Mr. Hawley, who did not pull the trigger in this offense, from Mr. Stevens, who did pull the trigger. They got the same offenses. If you look at the record, what it's littered with is, Mr. Hawley, I don't think you have enough remorse for this particular offense. What did the district judge rely on? January 10th, the hearing, when conflicted counsel put Mr. Hawley on the stand. At that point, conflicted counsel had not even read the trial transcript, that's in the record, and then he proceeded to cross-examine his own client about, A, when were you in jail that day? B, well, didn't you receive a text message when you said you were in jail? C, but didn't you supply the gun and dispose of it afterwards? So, Mr. Hawley, my client, doesn't this really not even matter? That's what his counsel did. So when we talk about was there a conflict, look at whether Mr. Protegiru, Hawley's counsel, thought there was a conflict. Look how he behaved at that particular
But
hearing.
I guess, and maybe I won't speak for Judge Thacker, but I guess what we're trying to ask is, for purposes of resentencing, how does that affect? I understand for your argument if we were at a motion for a new trial, but for purposes of resentencing before the district court judge, who is aware now that he was in jail during this time, if that is a mitigating factor, how does that affect the resentencing where the judge does know this, where the judge knows this?
Well, I think it's important to say that it's not we don't have to show that a different outcome would have been reached. We don't have to show that a different sentencing outcome would have been reached.
But you do have to show that counsel, there was a strategy that they should have pursued that they didn't pursue, and there's a link between not pursuing that strategy and the conflict.
Correct.
I understand that to be Judge Benjamin's question.
Right, so they did something that they shouldn't have done, which is put their client on the stand at January 10th, have him testify, cross-examine him, having not reviewed the record, and then we can directly link that to the sentencing on April 18th. The district judge is citing his testimony from January 10th. At the January 10th hearing, the district court contemplates, says, I don't know, I'm not reaching a decision here, but the government had argued that this might be appropriate for an obstruction enhancement. So he put his client in a terrible position.
Well, was that the attorney, or was that the client saying, I mean, he's the one who wanted to file the motion saying, I didn't do it, I couldn't have done it, right? That, if anything, that's the problem.
Well, I think the problem is we keep talking about the motion for new trial. What actually...
Which is not on appeal, right?
Correct. We don't have a
Okay.
good faith argument against the judge's ruling that was 12 years out of time, something that certainly a pro se litigant would perhaps miss. The point, and when this was first raised, what Mr. Protogiru-Hawley's counsel said at the time was that we have an issue that's relevant perhaps to a motion for a new trial or relevant to sentencing. And at that point, Mr. Protogiru realized he had a conflict, and that conflict inhibited him from, he started looking out for himself and put Mr. Hawley on the stand to say,
Was there an obstruction enhancement based on that January testimony of Mr. Hawley?
there was already an obstruction enhancement applied at the original sentence. There wasn't an additional obstruction enhancement.
So that did not impact the resentencing?
No, but the testimony itself did, Your Honor. The testimony itself, the judge repeatedly cites, Mr. Hawley, you were on the stand January 10th. You have said things, you said you had the gun, you provided the gun, you kept the gun, and so why did his counsel put him on the stand under those circumstances where the chief factor that the judge used to differentiate Mr. Hawley from Mr. Stevens, who again pulled the trigger, was that I don't think you're remorseful enough about this offense, Mr. Hawley, and so I'm going to give you the same sentence that I gave the person who pulled the trigger. And again, what was the judge relying on? This had happened 12 years ago, had a very recent
Which was a
opportunity.
downward departure, right?
Your Honor, I'm sorry.
The sentence was a downward departure, right, from what the guidelines said he should get?
The government was arguing for 60 years. He got 40 years. He had asked for 20 years. So again, I know the government says that his counsel did, quote, a highly successful job. Well, he asked for 20 years and he got 40 years for an offense he committed when he was 18 years old. So
He could have gotten 60 years.
yes, Your Honor, he could have gotten 60 years.
You have 2 minutes in rebuttal.
Thank
Your
you, Your
time.
Honor. Thank you.
Right, and we'll hear from the government.
May it please the court, Rebecca Gant on behalf of the United States. This appeal arises from a resentencing 12 years after defendant was convicted for his role in 2 attempted robberies and conspiracy. The defendant provided the gun for the attempted robberies, which was ultimately used in the murder of the store employee, Mr. Robert Nelson. The defendant then disposed of the gun after the murder, and after he was charged, perjured himself in a suppression hearing. The defendant was originally sentenced to life plus 5 years. At the resentencing, he had the same offense level off the charts at 45, the same criminal history category of 3. The district court sentenced him to 40 years, well below the statutory maximum sentence and restricted guidelines range. The defendant also raised a last-minute new trial motion, which the district court ultimately denied, and the defendant never appealed. I'll take the claims of error in the same order as the defendant, starting with the consecutive sentences. The defendant has failed to establish any presumption or bar against consecutive sentences in this situation. As the court has already noted, that's been conclusively established in the Oliver decision. All that 3584B requires in this situation is that the court look to the 3553A factors in making the determination, and there's no argument that it did so here. Its decision to run the sentences consecutively was also consistent with Section 5G 1.2 of the guidelines. The district court also had discretion here under the sentencing package doctrine, which recognizes that a district court may have an overall plan and seek to achieve a sentence consistent with the original sentence. And here the district court imposed a sentence of 40 years, which was still below the life sentence originally imposed. I'll turn now to the grouping unless the court has questions on consecutive sentences. First, any error on grouping was clearly harmless, where the offense level had not changed and where the district court imposed a significant downward variant sentence. The district court gave no indication that the grouping analysis drove its ultimate decision on the sentence here. Instead, it thoroughly went into other factors that led to its decision to impose a 480-month sentence. And I don't think this court has ever imposed some sort of magic word requirement where the district court is required to say, I would have given the exact same sentence regardless of any errors raised on appeal.
Could the district court, regardless of the grouping, still consider the offense conduct in determining the ultimate sentence, regardless of how they're grouped? I mean, could it still factor into choosing where, and I mean, there's no range here. There was one guideline sentence, but in choosing where to sentence the defendant?
Certainly, Your Honor, the court could consider over how many days the conduct took place. The district court mentioned that there were 2 different attempts, that the defendant's co-conspirators went into the gold shop on 2 different days, and that did seem to have been somewhat important to the court. The grouping and the decision not to group is also entirely appropriate under the analysis that this court set forth in the United States v. Pitts decision, which looks to factors including breaks in time, the means used, the participants involved in the attempts, and the separateness of fear and risk of harm. 2 unpublished decisions by this court are also instructive. The Chambers decision, which affirmed a lack of grouping where there was the same victim over a laundering and larceny offense, and the Moore decision, where there were 2 arsons of the same house. And in both instances, the court affirmed the decision not to group. The guidelines commentary here, which the court looked to in the United States v. White decision, also supports the grouping decision, and particularly the comment in section 3D1.2, note 4, that robbery of the same victim on different occasions involves multiple separate instances of fear and risk of harm, not one composite harm. I'll move on to the disparities argument. The principal argument in the defendant's brief is that the district court was somehow obligated to sua sponte, look to national statistics that were never presented to the district court. I don't think there's any case establishing that that's something the district court is required to do, and let alone that this would be plain error since this argument was not raised below. In any event, the claim of error doesn't survive review under any standard. The database that the defendant points to on appeal shows exactly what the court has cautioned before, that this is a treacherous inquiry to look to other cases. There's also no requirement that this court has established that when a district court consults national statistics, that it impose the average or median sentence. The 2 cases discussed in the briefs where the court did find error based on disparities with national statistics were far different differences than here. In the Freeman case, I believe the sentence imposed was double the national statistics, and in Brown it was more than double. What we have here is a median sentence of 420 months, which is relatively quite close to the 480 months Mr. Hawley received. As to comparison with the co-defendants, Mr. Hawley had the highest offense level of all the defendants in this case, and he was tied for the highest criminal history category with co-defendant Murray, who cooperated and testified at the trial. I'll move on to the conflict issue, unless the court has further questions on the guidelines. Case law is clear that the mere possibility of a conflict is insufficient to establish a claim. There must be an actual conflict that arises from a lawyer having to choose between his client's best interests and implicating him or herself in their own, quote, serious misconduct, and that's from the Glover decision. What we have here, at the very most, is garden variety claim of ineffective assistance of counsel, that trial counsel made a decision whether or not to cross a witness and what they would have crossed the witness on. This is far from something that arises to serious misconduct. The Glover case from this court is instructive. There, the court held that the serious misconduct standard was satisfied where the client had alleged that his attorney coerced him into his guilty plea, which the court emphasized went far beyond the normal differences in strategy, trial strategy, between an attorney and a client, and that this claim would amount to malpractice if true. If the court were to find here that this was a conflict requiring replacement of the attorney, I think probably every defendant who was convicted at trial would have a new attorney for sentencing, because I think most defendants are probably not satisfied with their attorney after convicted at a jury trial.
But the motion for a new trial ultimately didn't even include an IAC claim, did it? Not that, I mean, that came after the sentencing, but.
That's correct, Your Honor. Both the one after the sentencing, and then there was the one that the district court struck. I believe the subsequent one was much longer than the one presented to the court shortly before the resentencing. But neither of those raised any claim about what the attorney should or should have not done. The claims in those briefs were prosecutorial misconduct. Neither Mr. Hawley nor...
Assuming we find there was a conflict, what's your response to opposing counsel's argument that it did impact the resentencing because the court focused on Mr. Hawley's lack of remorse?
Yes, Your Honor. First, I would point out that there was no adverse effect argued in the opening brief of the defendant, so I would contend that that claim is waived. But I was puzzled by the representation by counsel today that the district court repeatedly cited back to the January 10th hearing at the resentencing. I didn't see that in the record. The district court certainly referenced as part of its analysis of the 3553A factors Mr. Hawley's remorse and what the district court viewed as its lack of remorse. But I think clearly in context and also explicitly, the district court was referring to Mr. Hawley's allocution. As the court noted previously, there was an objection about the obstruction of justice enhancement, and that the arguments of the parties in the district court's ruling focused exclusively on the perjury at the suppression hearing. And so I'm not aware of the district court finding that Mr. Hawley testified untruthfully at the January 10th hearing or incorporating that into its remorse finding. In fact, I think the fact that the adverse effect standard would not be satisfied is shown by Mr. Protegiro's explicit incorporation of the jail call records or the detention records, which he used as the basis of his argument for a minor participant enhancement. And the crux of the adverse effect analysis is that the defense counsel did not do something because of the asserted conflict. An example of that is this court's decision in Nicholson, where the court found that there was an adverse effect because defense counsel didn't raise a self-defense departure motion, and that's because the defense counsel had represented the victim as well as the defendant. So there was a direct connection between the asserted conflict and the claim of what the defense attorney did not do. Because we're on direct appeal, the defendant has to show ineffective assistance that is clear on the record, and I don't think we have anything close to that. It's notable that neither Mr. Protegiro nor his client ever raised a claim of disagreement regarding the resentencing. In fact, at Joint Appendix 886, Mr. Protegiro notes that he and Mr. Hawley have gotten along wonderfully, and there was no issue like that for the resentencing, and that he was prepared to go forward. Unless the court has further questions, I would ask that the court affirm the decision below. Thank you.
All right, thank you. We'll hear again from Mr. Irola.
Thank you, Your Honors. The government makes much of the fact of certain arguments that Mr. Hawley did not make at resentencing, but I think that ignores the reality that trial counsel was laboring under a conflict and was distracted and concerned with self-preservation. So I'm not sure that's the right prism through which to view these. I want to turn briefly to the disparity argument because I didn't get a chance to cover that last time. It's our position that the court abused its discretion in applying this factor under 18 U.S.C. 3553. That's so for two reasons. One is the law is clear. When applying this factor, the disparity with which the factor is concerned is discrepancies nationwide. It's not limited solely to the defendants to the case. That doesn't mean, contrary to the government's representations, that the court needs to sua sponte, look at the JSON database or some other specific source. But it does need to make a record for appellate review that it in fact considered and sufficiently considered this factor. And on the face of the record, that simply is not clear. Even
But here
within...
it would have sua sponte had to do that because appellant didn't raise it with the district court. It wasn't argued at the resentencing.
Well, I think, Your Honor, our argument is that there's procedural error insofar as the record doesn't reflect that the court considered this factor properly. I suppose there's a number of ways you could go about doing so, but there's nothing to suggest that they did anything other than...
Did appellant argue about offer national statistics or argue national statistics to the district court at resentencing?
Your Honor, he did not, and I think that ties into our broader arguments about counsel's conflict and the extent to which that impacted these proceedings. Even within this own case, however, there's unwarranted disparities between the sentences that were ultimately imposed and how Mr. Hawley and Mr. Stevens were treated here. They both received the same sentence, and much of that reasoning seems to be based on the court's perception that Mr. Hawley lacked adequate remorse and acceptance of responsibility. And Your Honors, I see him at my time, if I can just finish the point. The court placed undue weight on this factor for a few reasons. One, for starters, Mr. Hawley did express remorse, both at his initial sentencing and his resentencing. He didn't receive any credit for acceptance of responsibility, so he's already being punished for not getting the benefit of what would come with an acceptance of responsibility and cooperation. But two, these two defendants are differently positioned. As Mr. Young explained, Mr. Stevens was the shooter. He was a mastermind. Mr. Hawley's role is different. That doesn't diminish the severity of his conduct, but they were differently situated. And then the last point I just want to hone in on, which again Mr. Young touched on a little bit, was the undue weight placed on the remorse ignores the incredibly fraught situation that Mr. Hawley was placed in at resentencing. 3 months prior, there's a hearing in January where there's evidence, potential mitigating evidence that wasn't raised at trial that's the subject of a discussion there. Mr. Hawley, on his counsel's advice, testifies at that hearing and makes certain statements.
If you're going to get into what your co-counsel is talking about, that's fine. You can take his time. But I do have questions about that, or do you want to let him talk about that?
I want to let him address it. I just wanted to say that and I will cede my time. I just wanted to say that the extent the court placed undue weight on his lack of remorse because it didn't take account of the bind that they put him in as a result of this January 2024 hearing. But I will cede
All
my
right,
time.
yeah, we'll listen. Thank you. We'll
Thank you.
listen to Mr. Young on that point now, because I think we both have.
Thank you, Your Honor. I want to
So
be really...
please cite me to the JA where the district court relied on the January hearing for lack of remorse.
Repeatedly, like, as you said.
Yes, Your Honor. I don't have the record cite in front of me. but
And
I
it's
think-
not in your briefs because you didn't argue it in your opening brief. So when I read it, page 932, the district court says, he has not been remorseful. Even at the original sentencing, he was hesitant. He never said, I accept responsibility. And then on 933, she said, even today, he stands in front of the court and still never comes forward. He says, I never wanted to be a part of this. Are you sorry? So she's relying on the original sentencing and his statements at the resentencing.
Yes, Your Honor.
So where
When-
is she relying on the January hearing?
When they're arguing the objections that Mr. Protégé is arguing to the PSR, she talks about the fact that you were here in January and you admitted that you had the gun and you kept the gun. And I think that does feed into...
So that's not about remorse.
Well, I do think it feeds into remorse. I think it also feeds into the fact that Mr. Hawley's counsel...
Well,
had
at
not-
the part of the transcript you're talking about, does the district court use the word remorse or the word sorry in the way that the district court did in the portions that Judge Rushing just read?
Your Honor, I don't know that if it's necessarily proper to parse the transcript in that way. The court is looking at everything that's come before.
Well, I don't know that we're parsing. You said to us that the court repeatedly relied on the January 10th hearing and his testimony to find that the appellant was not remorseful enough. We're just trying to figure out where did the district court actually say that?
I didn't say that was, respectfully, I didn't say that was the only thing the court relied on in finding a lack of remorse, but it did to draw a through line from the January 10th hearing to the April 18th hearing. If he doesn't get on the stand on January 10th, the court can't cite to it at all throughout the April 18th sentencing. And it does just cite to what he said in trial or at the original sentencing. Thank you, Your Honors.
All right, thank you. And the court would like to particularly thank you, Mr. Irola and Mr. Young, for, we know you're court appointed, and we appreciate your representation and that of your co-counsel, Ms. Fierce, is it? Thank you very much. And we also, of course, appreciate the able arguments of Ms. Gant on behalf of the United States. We'll come down and greet counsel and go to our final case. All right, we're ready to hear argument in United States versus Williams. Ms. Ascari?
May it please the court. The cornerstone of the Fourth Amendment is reasonableness, and that certainly applies to the questions here. First, would a reasonable person hemmed in by cars and two marked police vehicles feel free to leave? And did officers have reasonable suspicion to seize Mr. Williams based on an uncorroborated anonymous tip? The answer to both of these is no. First, regarding the seizure itself, we raised a factual and a legal question. I'm going to start with that legal question. As this court knows, a person is seized when officers use force or a show of authority to demonstrate to someone that their liberty has been restrained. And the court asked, would a reasonable person, under the totality of the circumstances, feel free to leave? So here, what are the totality of the circumstances? Mr. Williams and his passengers were backed into a parking spot with cars on either side, immediately on either side, when two marked police SUVs pull into the parking lot in the center of the driving lane, and one, the first, partially blocking the front of Mr. Williams's vehicle. The second officer parked a car to length behind the first officer.
So for purposes of this legal argument, you're accepting the district court's factual findings?
Judge, we did argue that the court made clearly erroneous findings, but this court doesn't have to agree with that argument. That's not dispositive in this case.
Sorry, that was a question. I meant to put a question mark at the end. So for the purposes of this legal argument, you're accepting the district court's factual findings?
Yes, Judge.
Okay, so you're not arguing it was clearly erroneous to conclude that the patrol car did not block in the defendant's car. The defendant could get out of the parking space.
The district court found that Mr. Williams would be able to freely drive to the left or to the right. He didn't make a finding about whether he was blocked in.
Right.
And this court does not have to agree with us for the legal purpose that Mr. Williams could drive to the left or right once out of that parking spot. Our position is that, and Officer Pistone actually agreed as well on cross-examination, that his car was blocking that driving path to the left. And when the court looks at the photos that are in the briefs, but also in the body-worn videos, the court can see that Mr. Williams would have had to have taken evasive action or maneuvered in a way, a multi-point turn that this court has found constitutes essentially hemming him in or blocking him in.
That's not what the district court held, right? The district court said he could pull out either direction, and the officer testified he could pull out either direction, and the photos show he could pull out to the right with no maneuvering. So if we accept that, then do you have an argument that as a legal matter, he still wouldn't have felt that he could leave? He would have felt the officers were there for him and he couldn't leave.
Even if we accept Your Honor's fact pattern, yes, Judge, and yes, our position is that even under those circumstances, Mr. Williams was not free to leave. He did not feel free to leave. A reasonable person would not feel free to leave when you have these two marked police vehicles.
The other car felt free to leave, like one car left.
Yes, Judge, and that black car that Your Honor is referencing, there are 2 points there. First, that black car had more space to both the left and the right to maneuver out of its parking space. So it wouldn't have had to have taken a multi-point turn to get out of its parking space. It didn't have to. You can see it in the video.
There's an empty space next to the black car.
I'm sorry?
There was an empty space next to the black car.
Yes, Judge, there were. When you watch the body-worn videos, you can see, specifically Officer Wilson's body-worn video, you can see that there's ample space to the right of the black car, and there's space to the left of the black car as well. So it was able to get out of its parking space. In addition to that, the second point is, by the time that black car was leaving, Officers Wilson and Pistone were already focused on Mr. Williams. In fact, Officer Pistone was taking Mr. Williams to his vehicle. So at that point, the driver of the black car understood he was not the target of the investigation. Somebody else was. So he was free to leave at that point. But
And was the black car, in addition to not being as hemmed in as appellant's car was, the black car was also smaller than appellant's vehicle, right?
I believe that's correct, Judge. I don't have the measurements, and I certainly don't have them
Oh,
in
I
record, but it
actually
looks
do,
smaller,
because my
yes.
law clerk looked it all up.
Yes.
It was a Ford Fiesta.
It does appear, yes, Judge, to be a smaller vehicle. And as the court can see in the videos, did not have to take evasive action or maneuvering to get out of that particular parking spot. The officers also, in the way they parked, this draws a distinction from the Watkins case, which the government cites in its reply in support of its position, but actually it shows what these officers could have done or should have done in this particular case. Officers in Watkins parked on the far side of a driving lane in a parking lot and 3 car lengths down from Mr. Watkins. Here, if officers wanted to communicate to somebody that they were free to leave, they could have done that.
I thought there was only one police car in Watkins.
Yes, Judge,
right?
that is correct.
And there's 2 here.
Yes, Judge, that is absolutely right. So this court.
This is a parking lot, and there are multiple cars, and there's a driving lane, and it's in a housing complex. And 2 officers pull up, no sirens, no lights or anything. 2 cars pull up, marked police cars, and they stop kind of on one lane of the driving lane. It's kind of a 2-lane road. And they're stopped there. They're not blocking any of the cars in the parking lot. They stop in front of one of the housing complex's buildings. So your argument is, or has to be, that by pulling up and stopping, that someone in that parking lot or someone in that housing complex feels particularly singled out that I am not free to leave. I am being seized by the police individually. So who is it? Is it all the cars in the parking lot? Or is it someone in the housing I mean, why are you drawing the line where it is? It seems to me that, I mean, you cite these cases about it's seemingly at random. And this does seem at random. It's not a patrol. Clearly the officers are there for something in the housing complex. But an innocent person in the parking lot, you know, if this fellow was about to go get groceries, I mean, the officers pulled up, he would have thought, something going down in the apartment. And he would have pulled out and gone to get his groceries, right? Because he could. So who is it that should have felt seized and why?
Judge, certainly if the officers had parked on the far side of that driving lane where they did park, maybe a reasonable person would think, oh, they're here for some reason. but these officers parked in the middle of the driving lane, which is unusual. They were together, which communicates, as Your Honor acknowledged, that there was something going on. And that first vehicle, Officer Pistone's vehicle, parked perpendicular and partially blocking the front of Mr. Williams's car. So a reasonable person in that position is left to believe that the car blocking me is here and focused on me, that I'm the target of the
What about all the
investigation.
other cars in the parking lot next to him that my colleagues just pointed out? There were cars on either side of him, there's a car further down, they're all seized.
There was nobody in those vehicles,
But
Judge.
if there had been,
If there had been, potentially there would be a different scenario, and potentially those individuals would have felt not free to leave. Here we have Mr. Williams,
Wasn't
who was
there
the
also
only
somebody
individual.
standing next to the car that ran away as the police drove up?
Judge, I don't recall that from the record. And if there was, and if that person had been our client, then I imagine we would have an acquiescence
Somebody named
issue.
Frank.
But, I'm sorry, Judge?
Somebody named Frank, when in the video, the officer asks appellant, who was the guy that pretty much sprinted out of here when we pulled up, and appellant says, oh, Frank, he was standing outside the car. I thought that was in the video, maybe not.
That may be, Judge, and perhaps I missed it. And that would actually go to our point that Mr. Williams did not feel free to leave, he did not leave, and he
Right.
certainly acquiesced to
And
that
it
show
would
of
go to
authority.
that point, but then I think it may cut against you on the reasonable suspicion, even assuming that there was a seizure at the point they drove up. Then if there's somebody that runs away right when the police drive up, that adds to the reasonable suspicion of not only they have the call and then they find people that match the description in the call.
It potentially would, Judge. I would point out the government hasn't made that point. The government hasn't argued that. In addition to that, Judge, going to...
I know that same law clerk that found the Ford Fiesta also found Frank.
Very diligent law clerk, Judge.
But wouldn't that be reasonable suspicion as to Frank? He's the one that took off running.
Yes,
Not
Judge.
necessarily Mr. Williams.
Thank you. Yes, Judge.
Frank felt free to leave. I mean, if Frank is a real guy, he felt free
If
to
he's
leave,
real,
right?
yeah.
And everyone else should have felt free to get out of that car and leave too. Maybe don't run, because that's suspicious, Frank. But, then how does that help you?
And
Judge,
he was also standing right next to appellant's car. He was with appellant.
Yes, Judge. So there are two issues there. First, the individual, again, who ran, I don't know Frank. I don't know what led him to run. But what I can say is that the fact that he ran indicates, and the fact that Mr. Williams didn't, indicates that Mr. Williams was acquiescing to that show of police authority. He did not bail out of a car. He did not get out of the car and leave.
He may have been too high to run. I mean, wasn't that the issue?
Judge, I'm not sure. They didn't do roadside. I know they indicated that they did smoke something. They didn't say when. That was certainly after the seizure. Regarding the anonymous tip and Judge Thacker, your concerns, I believe that Judge Benjamin actually pointed out a very good point, that may go to reasonable suspicion as to the individual who left. That headlong flight would have maybe caused some suspicion about him. But in terms of the anonymous tip, we have the court had to find some illegality, the officers rather had to corroborate the illegality of that call. Was there actually any sort of illegality? An individual running when the cops come, that's unclear. The cops didn't say that they suggested that there were hand-to-hand transactions happening, and actually the information that they learned, albeit after the seizure, was that there was no indication of hand-to-hand transactions. So the officers relying on that anonymous tip, an individual running away at most, certainly didn't corroborate it enough for a seizure in that moment. Again, the officers could have done what they did in Watkins. They could have parked further away and engaged in a citizen encounter, and they simply didn't do that in this particular case.
Does it matter That the officers didn't have on the sirens or lights when they pulled up?
That's
In
something
terms
the
of
court,
seizure?
I'm sorry?
In terms of the seizure?
That's certainly something the court can take into consideration, but we know from this court's opinion in Jones that that is certainly not dispositive. The officers in Jones hemmed in Mr. Jones. They did not have on their lights and sirens, and the court still found that Mr. Jones was actually seized in that particular situation.
Would you say Jones is your best case for why this case is a seizure?
Yes, Judge.
And that's the case where it's a one-lane road, right? And the officers blocked the lane of travel, and he would have had to back out and back down, going the wrong way to get out. That was Jones, right?
That was Jones, yes, Judge. And in one of the footnotes, I believe it's footnote 4, the court acknowledged that the government argued, well, he wasn't actually blocked in, he could have backed out. And the court there said, if someone has to take evasive action, they're not going to do that in front of police officers. And that does suggest that they were seized. And again, that's what Mr. Williams would have had to have done. He was to take evasive action or maneuver his car in a way that a person just would not do.
So that's kind of a dispute with the district court's fact findings, right? That pulling out of the parking space would have had to require evasive actions.
One moment.
Which you can do, it's just a high standard, right? We have to find clear error.
If we're talking about the factual question, yes, Judge, it is clear error. The district court found that Mr. Williams would have been able to drive to the left or to the right. The court did not make any findings about any maneuvering he would have to do to get out of the parking spot to go to the left or to the right. It may be possible that Mr. Williams could have eventually gotten out of that parking spot, but in order to do so, he would have had to have taken a multi-point turn. And again, the court in Jones...
So I have to, you're saying I don't have to find clear error, but I have to accept your description instead of these pictures, right? That he couldn't pull to the right.
Judge, no.
The video, right? The video, I mean, I can see on the video what
Your
he
Honor,
could do, and the district court made a finding. But your argument is the video doesn't accurately show it, and the district court's factual finding is not correct, that he couldn't have pulled out at least to the right. It would have required lots of maneuvering, even though he was backed in.
Our position is, and I apologize, I see I'm over my time,
You can
Judge.
answer.
Go ahead.
Thank you. The district court's findings don't reach the ability of Mr. Williams to maneuver in or out of that parking spot. But even if the court believes that it does or finds on its own that it does by watching the video, the fact that these two marked police units parked in the way that they did was a show of authority, and a reasonable person would not have felt free to leave under those circumstances.
All right, thank you. Ms. Wood?
Good morning. May it please the court. Julia Wood on behalf of the United States. I want to start just by talking briefly about the footage. You mentioned, Judge Thacker, about Frank.
Yeah.
That is I noticed it in my preparation and review. It's at 1925-47 of Exhibit 6. And the officer does ask, who was that guy who basically just took off running when we pulled up? And he said, that's my friend Frank. I think that does go to the reasonable suspicion if this court were to find that there was a seizure. The 911 call
And yet
said that there
the
were...
government in its briefing doesn't mention Frank and him running away anywhere. So all you have in your briefing on reasonable suspicion is an anonymous phone call and then people matching the description of the tip.
That's right. We did not raise the issue of Frank.
Because
did
that
not
would be
come up at
reasonable
this.
suspicion against Frank. That's why that's probably why you didn't raise it, because the reasonable suspicion would be against Frank.
Well, it didn't come up at the suppression hearing. I think it does go to reasonable suspicion when you have a 911 call that's alleging drug transactions, and it was reasonable for the officer to infer from the information that the 911 dispatcher gave him that that was a contemporaneous report.
Wasn't Frank standing outside appellant's vehicle before he fled?
That is what they said, but that would be consistent with a drug transaction of,
I thought he just asked who was that guy.
he asked who was that.
Took off sprinting. I don't know if was it ever a conversation about where Frank was standing.
Their appellant responds and he says, "Oh, Frank," and then he says he's from here too. He wasn't in the car; he was standing outside.
It's about 45 seconds later, they're talking about where Frank was standing, because he said, was he in the car too? And he was like, no, he was standing outside the car. But I think that when you have this 911 report that had sufficient indicia of reliability, that would add to the reasonable suspicion.
How is a 911 report reliable? It's anonymous, and we have case law in the circuit. It's anonymous. We don't know who the person is. He says there's a car, and there's I think he says some light-skinned black dude in the car, and they may be doing something illegal. He doesn't even say what they are doing that is illegal. He says they may be doing something that's illegal. How is that reliable?
Well, first
under
of all,
our case law.
Under Navarrete and this court's decision, in Kehoe, I think it does have, this court has said in Perkins that anonymity of the call is a spectrum. Not every call is either anonymous or non-anonymous. This one had those 4 indicia of reliability. It was placed to a 911 call, and it was therefore traceable. The caller was saying, it appears that they're doing drug transactions. They're currently parked by the pool. There are 3 to 4 people in the car. I don't see any weapons. Those are all indications that he's an eyewitness and that he is seeing things that lead him to believe that they're doing drug transactions. And the officer Pistone corroborated some of the key details of this call when he arrived on the scene. There was a white Mercedes-Benz with a light brown-skinned man with braids in the car, and it was parked by the pool. So they did corroborate that information.
Illegal?
And that's not, it doesn't go to the illegality of what the caller observed, but the Supreme Court has said in Alabama v. White that if you corroborate some aspects, then the caller is more likely to be telling the truth about other aspects of the call. But I would like to get back to whether whether a reasonable person would have felt free to leave in Mr. Williams' position. The district court did not clearly err when it found that there was room for him to drive away either to the left or to the right. I think the body-worn camera footage shows that, and the district court relied on that footage.
But the district court did not discuss. The district court did not discuss if he would have had to maneuver to go to the right or to the left. And from my viewing of the video, there would have been some maneuvering to go to the right or the left. Is that not clear?
The district court didn't have to consider or didn't have to state on the record whether he would have had to maneuver. His finding is plausible in light of the record, and that is all this court needs to find that he did not clearly err. And in Watkins, which I think is on point with this case, the car would have had to back out before it then left the parking lot, but this court found that he was not, or affirmed and found that he was not blocked in.
Yeah, but in Watkins, if I'm remembering correctly, the police officer pulled in 3 spaces down, so it's not in front of the vehicle.
That's correct. I think if you
and it was only 1 police officer, not 2 police officers that arrived simultaneously in a high crime area.
And that is the key difference with Watkins is the 1 officer versus 2 officers. But I still think, to Judge Rushing's point, that when 2 officers arrive, they don't have their sirens on.
That's not the only difference. It's multiple officers arriving at the same time and partially blocking the vehicles. Where they parked is different than where the 1 officer in Watkins parked.
But I don't respectfully think that they partially blocked. Officer Pistone pulled his vehicle past the white Mercedes, and then Officer Wilson was on the other side of the white Mercedes and on the right side of the driving lane. So there was room to drive away, and that black car, which may have been a bit smaller than the white Mercedes, but it was able to pull away.
And well, that, not only was it smaller, it didn't have cars next to it in the way that appellant's vehicle did.
Right, but there was, it wasn't really a tight wedge. There was room on either side of that white Mercedes. One of the doors was opened without hitting the car beside it. So there was, and the police cars, when you look at the
really,
footage.
I guess I feel like we're getting a little bit afield, because the question is not whether he physically could have made it out of there. The question is whether he felt like he could even attempt to leave.
And I think he could. All of this goes to whether he could have, whether he would have felt free to leave, because the officers did park in a way that left him room to simply drive away.
What about the fact that it's a high crime area? So people that live in that area, and I think he said he's from the appellants from the area, already know that the police are suspicious of every movement, even just sitting in a car next to the pool. Does that play into whether he would have felt free to leave when two police cars roll up and park in the manner that they did?
I think it actually could cut in the other way, that there was no reason for him to believe that he was specifically being targeted. If this is a high crime area, the police officers could have been there to investigate someone else in the building. And this court has said that this is an objective test. It's more about what the officers are doing, their show of authority, whether they are, giving that requisite show of authority where somebody would not have felt free to leave. And in this case, where they, drove up, no sirens, no lights, they did park on the, on the right side of the driving lane and leave room. And I do want to, my friend does not challenge that they smelled marijuana when they opened the door. So we're talking about a short.
Right. But if they were seized already, right from the get-go, then opening the door doesn't really matter for reasonable suspicion.
Right, that's exactly right. But we're talking about
So I'm trying to find out, if I do think that they were seized right from the get-go, that appellant was seized right from the jump, then what are the indicia of reasonable suspicion I should be looking to at that point?
At that point, I think we have the 911 call, which does have those indicia of reliability under Navarrete and Kehoe. The corroboration of the details of that 911 call also rendered it more reliable. And we have that it's a high crime area, which I understand under this court's precedent, standing alone.
How you say it's reliable, because it says if it's an anonymous call, it seems as if the cases say that then the assertion needs to be pretty definite, right? If you look at the Supreme, I think it's Florida versus JL, and those cases said that assertion of illegality. This guy says basically they may be doing. I don't know what they're doing. They're just sitting out there, but they may be doing something. So that's. That doesn't seem to be, to me, very reliable. He's not saying I saw them. I see them out there selling drugs. I see someone doing a hand-to-hand transaction. It seems as if you would need something more than just these guys are sitting in the car. One of them is light-skinned with braids in his hair, and they may be up to something illegal.
So 2 points. When the caller called, he said, "These cats are out here selling drugs." And then later on, he said, "I think they're doing a drug transaction." But he first said, "These cats are out here selling drugs." And during the call, he actually said, "I've told them before." So he had some, and he said he lived in the complex, so he had some previous history of seeing this kind of conduct.
But he doesn't say that he's witnessing a drug transaction.
Not a hand-to-hand transaction, but I think it's certainly reasonable for the officer to infer, based on the information that he had, that this was an eyewitness account. He said it appears that they're making drug transactions. They're currently by the pool.
Did that information go to the police officers?
That information he had not listened to the 911 call, but he did have the call for service that had, the language was, advises same appears to be making drug transactions, currently near pool, has 3 to 4 occupants in the vehicle, no weapons seen, which all, it was reasonable for Officer Pistone to infer that this was an eyewitness account and it was contemporaneously happening. I also want to draw a distinction with Florida versus JL. In that case, the weapon was that the tipster had called about was concealed, and he didn't give any basis of knowledge. There was no way for him to know that this person was carrying a gun. But in this case, you can see drug,
He doesn't, the witness doesn't say that he sees him, there's a hand-to-hand drug transaction?
He didn't say that there was a hand-to-hand drug transaction, but when he called, he said, these cats are out here dealing drugs.
But that wasn't given to the police officers that arrived on the scene. That part of the conversation was not, that's not what was told to the police officers that arrived on the scene.
Well, the call for service said advises same appears to be making drug transactions.
Appears.
Appears.
It looks like
yes.
the CAD sheet says drug sale / purchase, suspect on scene, right?
Yes, that's correct. That's at JA 59.
That's
Thank you, Judge
what
Rushing.
the officers were told.
Yes, that's what the officers were told. So they had that information. They also had the information that it was a 911 call. So, under the Supreme Court's precedent and this court's precedent, because he called 911, that makes it. And the district court also found that made this more of a traceable call. Let's see. The high crime area, again, standing alone, that would not be enough, certainly for reasonable suspicion, but it does play into the analysis under the totality of the circumstances.
Does Frank matter at all for the reasonable suspicion analysis, assuming that the seizure occurred right from the beginning?
I think Frank does matter because this court can affirm on any grounds found in the record. I think it adds to the reasonable suspicion that once the officers drove up to investigate a call for service of drug transactions, there was a man standing at the identified car and he took off. I think that is suspicious behavior that could play into the reasonable suspicion analysis. As to Frank. And I would argue to the entire car, because if Frank is running away and we have a call for service on drug transactions, I think it's a reasonable inference that perhaps Frank and Mr. Williams or the occupants of the car were engaged in a drug transaction.
But no one ran after Frank.
Nobody ran after Frank that we are aware of. I do want to just address very quickly, the district court didn't clearly err when he found that he could drive to the right or the left. And also, there were many non-evasive ways that Mr. Williams could have left. It would not have required evasive action for him to simply drive off to the right. If driving past a police car were evasive action, then, people would be seized anytime a police officer pulled up in their vicinity. So I just did want to make that point. But if the court has no further questions, we would ask that you affirm.
All right, thank you.
Thank you.
Judge Thacker, Frank matters insofar as Your Honor pointed out, this is a high crime area where people are potentially afraid of the police. This individual ran, that is all the officers know, but what we do know from JA 120 is that Officer Pistone said, he testified, that he was responding, he and Officer Wilson were responding to possible drug transactions. They did not know that there was any sort of eyewitness account of confirmed drug transactions or that anybody said there were drug transactions happening.
Is the word possible, or you're relying on, is that from his testimony? You're pulling that from his testimony in front of the court?
Yes, Judge, page JA 120.
So was he saying, I did not know at the time?
He said he was responding to possible drug transactions. Yes,
Right,
Judge.
but
So
he didn't
that's-
disavow the CAD, right?
No, Judge,
You
that-
seem to be saying that he said he didn't know there was an allegation of a drug sale, that he just thought it was possible.
Yes, Judge, that's correct. He said that he was responding to possible drug transactions.
Even though the communication that he had says same appears to be making drug transactions?
Yes, apparently, Officer Pistone's interpretation of
Appears is possible?
means possible. Yes,
Okay.
Judge. It's,
You seem to be putting a lot of emphasis on the way he said it in his testimony, right? I was responding to a possible drugs transaction. That doesn't mean that the CAD, I mean, it says, we can read it, right? It says drug sale / purchase, suspect on scene.
yes, Judge,
That's what he was told.
he was told that there appears to be drug transactions, and that he testifies that he understood that to be possible drug transactions. He didn't say understood that, but that's his testimony. And he testifies that when he arrives, he acknowledges he doesn't testify he doesn't have reasonable suspicion, but he acknowledges that he's there to investigate.
Yeah, he testified he would have let him go if he had gotten out of the car and walked away or driven off.
That was
He
his
said,
testimony.
I would have let him go.
That was Officer Pistone's testimony, yes. So as that goes to whether or not he had reasonable suspicion, we understand that to mean he did not have reasonable suspicion when those cars stopped. And based on the anonymous call, and based on the Supreme Court's cases in Navarrete and Florida v. JL, we understand that those officers had to corroborate the illegality of any sort of behavior that was reported. They can't just use identifying information as the corroboration. So my friend talked about the corroborating information of these individuals in a white car in this particular parking lot by the pool. That's not enough. They had to corroborate some sort of illegality, and they just didn't do that before the seizure. In addition to that, the government argues that the call was traceable. The district court mentioned, well, this was a 911 call, it would be traceable. This court's familiar with technology. People engage in swatting. I can borrow somebody's cell phone. People use burner phones. Whether or not a 911 call is potentially traceable does not make it more reliable. And this court, and again, the Supreme Court has said over and over, that's not enough. This
I mean,
case
you could
is,
give a fake name, too. I mean, that would throw out the entire category of anonymous versus non-anonymous. If someone, I mean, he could call and say, this is Joe Smith giving a report, you know, here's my phone number, here's my home, here's my address, here's my social security number. And the argument you just made would have us say, well, none of that gives it reliability, because you could make all that up. That could all be fake.
that is a possibility, Judge, but this court understands that when a person provides their name and their phone number, and the court acknowledged that in the Kehoe decision, that a person is putting themselves in a position to potentially be contacted again.
Why isn't it the same thing with a traceable phone number on a 911 call?
We just simply don't know where that phone number would be traced to. For example, I could, again, borrow.
Traced to what he called from.
Potentially, Judge, but the problem is we don't know if that's the person who's making the call. Again, I can borrow someone's
I mean,
phone.
I don't want you to get stuck on this, but I mean, that's the same, you could raise the same argument about what you just said is reliable when someone gives their name and their phone number.
Yes, Judge,
Right,
and
so that seems to be kind of an over-argument.
insofar as the court has that concern, this court has actually drawn the distinction for us. The court has recognized that where somebody identifies themselves, that gives an indicia of reliability that we look to when someone makes a 911 call that we simply don't have here. We would ask that this court reverse the district court's rulings and remand. Thank you.
All right, thank you, and we also thank you for your work, Ms. Ascari, on behalf of Mr. Williams, and Ms. Wood for your work on behalf of the government. And we'll come down and greet counsel and adjourn court until tomorrow morning.
This honorable court stands adjourned until tomorrow morning. God save the United States and this honorable court.